Hi, this is Dr. Perry Carpenter. I'd like to thank you for taking the time to join me on today's program. On today's program, we're continuing with our new and ongoing series entitled The Precedential Cases, the Medical Legal Game Changers. And the philosophy of this program has to do with those important cases that have come down through the Workers' Compensation Appeals Board over the years that contain within the decisions important principles and procedures that are illustrative and operative in every single evaluation that we do. So of all the cases that are interesting that I could share with you, these are the cases that it's important to be aware of the teaching principle contained within the case in each face-to-face evaluation that you do and in the construction and composition of your final report. These are the cases that are operative in every single evaluation that you do. And I've selected 6 of the most interesting and relevant cases to share with you in this series. Now, in our last session, we talked about the Escobedo decision. And the important points from the Escobedo decision have to do with 2 things. Basically, the Escobedo decision had to do with the qualified medical evaluator's opinions on apportionment. Although the principles that apply to apportionment, as described in the Escobedo case, apply to every single opinion and conclusion that you offer in your report. And that is that every single opinion and conclusion that you offer in your report, not only your opinion and conclusion on apportionment, but also your opinion and conclusion on permanent impairment, your opinion and conclusion on causation. And in your report, in every opinion and conclusion that you offer, that opinion and conclusion must qualify as substantial medical evidence in order for that opinion and conclusion to be something that the parties can rely upon. And it's interesting, if you can qualify your opinion and conclusion as substantial medical evidence, in other words, if you can take your opinion and conclusion, whatever that may be, and pass it through the filters of substantial medical evidence, the opinion that falls out of the bottom of these filters, if your opinion actually does fall out of the bottom of these filters, there's a very high likelihood that that opinion and conclusion has its actual basis in truth and fact. In other words, an opinion that is not true, an opinion that is not factual, that is not actual, that is not a true representation of the examinee's actual situation, that opinion will get trapped in the filters of substantial medical evidence. So it's a great way. The system described by Escobedo in qualifying your opinions as substantial medical evidence is a great way for you to test the authenticity and the veracity and the accuracy and the appropriateness of your opinion on the matter. If your opinion successfully makes it through the filters of substantial medical evidence, then you can feel confident that your opinion is probably an accurate representation of the examinee's true condition, true situation, true circumstance, whatever the case may be. So that was the first principle of the Escobedo decision. The second had to do with the importance of the mechanism of injury as relates to your apportionment determination. So as we know, according to Escobedo, which was largely about apportionment, your apportionment determination, in order for that determination to qualify as substantial medical evidence, the determination must be based on what Escobedo described as relevant facts. Relevant facts. And of all the relevant facts that go into your consideration of your apportionment determination, in other words, in coming up with your approximate percentages of the percent of permanent impairment due to the industrial injury and the percentage of permanent impairment due to other factors, the most important of the relevant facts that go into that consideration have to do with the mechanism of injury. The mechanism of injury. So the mechanism of injury is one of the subjects that you want to pursue in great detail in your history taking with your examinee, because later on in your report, if the examinee qualifies for permanent impairment and you're required to make an apportionment determination, your apportionment determination is going to depend in great measure upon details and relevant facts extracted from the mechanism of injury. So these are principles that apply to every single report that you put out. So Escobedo was a fascinating case in bringing us these important principles. Today we're going to talk about the Almarez and Guzman decision, and I'll save the details on that for today's discussion. In our next session, we're going to talk about the Cannon case, the Kite case, the Benson case, and the Mendoza-Garibay cases. And these are all cases that beautifully illustrate some of the principles associated with deriving your permanent impairment opinions and conclusions. The Benson case has to do with apportionment conclusions. And the Mendoza-Garibay case is a fascinating case that I'll just say has to do with liberal application of the liberal construction philosophy that we extend toward injured workers throughout the course of our evaluation. So I have some fascinating cases that I want to share with you, and your fluency and familiarity with these cases will dramatically impact the content and quality of your very next QME report. And today I have some fascinating information to share with you regarding your permanent impairment opinion and your alternative permanent impairment opinion under Almarez and Guzman. Okay, so let's begin today's discussion regarding the Almarez and Guzman decisions. Okay, so let's begin with some background on Almarez and Guzman. And it's important to realize that these cases came around at a time when we were undergoing a transition from our prior 1997 permanent disability rating schedule and transitioning into the new 2005 permanent disability rating schedule. And this transition occurred as a result of the April 14, 2004 passage of Senate Bill 899. Now, Senate Bill 899 required that effective 1105, our method of rating permanent disability transition from our prior schedule to a new schedule that involved the use of the AMA guides. So these Almarez and Guzman cases came about and kind of got caught in this transitional phase between the old system of rating permanent disability and our new system for rating permanent disability. Now, another important point to remember is that at the time, the purpose of Senate Bill 899 was an emergency measure which had as its purpose to attempt to address skyrocketing costs in workers' compensation. So many of the new rules and regulations codified by Senate Bill 899 had as their purpose to reduce workers' compensation costs. So both the Almarez and Guzman cases became disputed cases and contested cases because of the new implementation of Senate Bill 899, which dramatically reduced both of these examinees' permanent disability ratings under the new schedule, under the AMA guides, compared to what the prior schedule would have provided for both of these examinees. And so that created much of the discourse regarding both of these examinees. So with Almarez, Almarez had a November 5th, 2004 injury to the lower back. So this occurred after the passage of Senate Bill 899, but prior to the adoption of the AMA guides to the evaluation of permanent impairment. It's kind of stuck in that transitional period there. So Mr. Almarez had surgery, but he never returned to work. And under the AMA guides, he qualified only for 12% whole person impairment for a post-surgical lumbar spine. But the qualified medical evaluator provided for work restrictions that included a limitation to light duty work only, and he was permanently precluded from prolonged sitting. So now Almarez was a trucker, was a truck driver. So this work restriction of preclusion from prolonged sitting basically took him out of the pre-injury occupation, and he never returned to work. And it was this work restriction which, had Mr. Almarez been rated under the prior 1997 permanent disability rating schedule, this work restriction would have rated him much higher than a 12% disability rating. And so, because the disability rating came in under the AMA guides as only 12%, or I should say the impairment rating came in at only 12%, the applicant attorney objected to the whole person impairment rating and ultimately to the permanent disability rating. So the basis of the applicant's objection included that, number one, the labor code, which is Labor Code 4660, the labor code which requires the use of the AMA guides in the evaluation of permanent impairments under the new 2005 permanent disability rating schedule, the applicant argued that that labor code is not conclusive and it's not unrebuttable, and the applicant put forth a rebuttal to the AMA guides attempting to rebut the 12% whole person impairment and attempting to get approved or agreement on the permanent disability rating more related to the work restrictions under the prior permanent disability rating schedule. Very interesting. So the applicant was leaning more towards a disability rating related to our prior disability rating schedule by stating that the current disability rating schedule relying on the AMA guides was not conclusive and was not unrebuttable. They further contested that the AMA guides need not be blindly followed, where the guides do not completely and fairly describe the impairment, and it was the applicant's contention that 12% whole person impairment, which I believe ultimately translated into a 14% disability rating, that it was not fair and it was not an accurate description of Mr. Almarez's disability. Finally, the applicant contended that where the AMA guides do not fairly and accurately describe the impairment, other measures should be used, and in this case, the other measures that they were promoting involved a return to the 1997 permanent disability rating schedule. Now with Guzman was a female, and she suffered a cumulative trauma injury to her bilateral upper extremities through April 11, 2005. So you can see that, again, this case is caught somewhere in that transition between the old permanent disability rating schedule and the new permanent disability rating schedule at a time when all of the parties were grappling with some of these dramatic changes and dramatic reduction in workers' compensation permanent disability ratings under Senate Bill 899. So the qualified medical evaluator, or I think it was an agreed medical evaluator, he opined for a 3% whole person impairment for each upper extremity under the AMA guides. And this related to Ms. Guzman's bilateral carpal tunnel syndrome. So this came out of page 395 of the AMA guides in chapter 16. And the agreed medical evaluator opined that her condition most closely matched one of the descriptions on page 395 that provided for 5% upper extremity impairment, 5% upper extremity impairment converted to 3% whole person impairment for each upper extremity. However, the qualified medical evaluator also provided for 15% whole person impairment for each upper extremity based upon activities of daily living losses. And this was a permanent disability rating provided for under the prior 1997 permanent disability rating schedule. So what the qualified medical evaluator did is he provided a permanent disability rating on the one hand, according to the 1997 permanent disability rating schedule, and he provided a permanent impairment rating on the other hand under the new 2005 permanent disability rating schedule, and he called to the attention of the parties the difference or the differential between the disability rating and the impairment rating, and he deferred to the lower 3% whole person impairment rating because at the time it was the AMA guides that was the operative permanent disability rating schedule in effect at the time. Okay? Well, again, because of this dramatic reduction in the examinee or the employee's permanent disability rating, the applicant objected and they contended that number one, that the AMA guides calls for the evaluating physician to use his or her education, training, and clinical judgment in determining impairment, and therefore, based upon this qualified medical evaluator's education, training, and clinical judgment, that the higher permanent disability rating percentage should prevail, because it was this evaluator's clinical judgment that was the more accurate and more appropriate permanent disability rating. And they also contended that the AMA guides always defers to the evaluator's clinical judgment, and that the evaluator's clinical judgment over the accuracy of the permanent impairment or disability rating would prevail in cases where it was the evaluator's opinion that the AMA guides were not an accurate and true description of the examinee's permanent impairment. So these two cases arrived on the scene at around the same time, and they became, because the objections were roughly the same or had the same philosophic background, that evaluating physicians should not be locked into the AMA guides. If the AMA guides provide for a permanent impairment or permanent disability rating that is not fair, complete, or accurate, that the evaluating physician can depart from the AMA guides. So this became the basis of the appeal that made its way all the way to the Workers' Compensation Appeals Board, wherein the chairman of the Workers' Compensation Appeals Board and his group deliberated on the matter and came up with a final decision. And we refer to that final decision, it became known as an en banc decision. So in reading from the Almarez and Guzman case, they told us that in this joint en banc decision, we clarify and modify our previous en banc decision of February 3rd, 2009. So interesting that the appeals board created an en banc decision which was further contested by the parties. Even an en banc decision was contested by the parties, which required the appeals board to revisit the matter and come up with a new decision, a new en banc decision. And this final en banc decision became a binding precedent on all appeals board panels and workers' compensation judges. So the principles espoused by the Almarez and Guzman en banc decision became operative principles that apply throughout the whole state of California in all of the districts and all of the courts that hear cases involved with permanent impairment. So these are important principles that are still operative today in every single case that we deal with that involves permanent impairment. So in order to understand the evolution and the philosophy behind the Almarez and Guzman cases, it's important to understand the law behind Senate Bill 899 that brought into operation the AMA guides as involved in determining permanent impairment. So let's take some time and delve into Labor Code 4660.
Okay, so let's talk about Labor Code 4660. Now, Labor Code 4660 was part of the Workers' Compensation Reform Package that was passed with Senate Bill 899 in 2004, and then which became effective 1/1/2005. And it's Labor Code 4660 that ushered in the new era and the new permanent disability rating schedule that incorporates the AMA guides that we are currently using here in the state of California. So Labor Code 4660 is current law, and this is the law under which we are currently operating when it comes to determining permanent disability ratings for examinees. So Section A of Labor Code 4660 tells us that in determining the percentages of permanent disability, account shall be taken of several things. several things go into the final permanent disability rating that is assigned to injured workers. So number one is the nature of the physical injury or disfigurement. And this is the realm of the qualified medical evaluator. It's the qualified medical evaluator that reports on the nature of the physical injury or disfigurement by providing a permanent impairment rating through the use of the AMA guides. So this, number one, this is the contribution of the qualified medical evaluator. The second thing that's taken into consideration is the occupation of the injured employee, so that the same injury could result in a different impairment rating or a different permanent disability rating based on the occupation of the examinee. So, for example, a vocal cord injury signifies a much greater loss to an opera singer than it does to a jackhammer operator. So the occupation of the injury gets factored in to the final disability rating. The third thing is the examinee's age at the time of the injury, so that younger employees, younger injured workers, are afforded higher permanent impairment ratings because they have longer and more working years ahead of them than do older or aged workers. And then finally, there's a consideration being given to an employee's diminished future earning capacity, and this is accomplished through the use of a diminished future earning capacity adjustment factor, which is a multiplication factor. So numbers 2, 3, and 4, the diminished future earning capacity adjustment factor, those are all taken care of down at the disability evaluation unit. So the disability evaluation unit relies upon the qualified medical evaluator's permanent impairment rating in order to apply the occupation, in order to apply the age, and in order to apply the adjustment factor to the impairment rating to come up with a final disability rating. So let's talk about how the nature of the physical injury or disfigurement is established through the use of the AMA guides. So Labor Code 4660B tells us that for purposes of this section, the nature of the physical injury or disfigurement shall incorporate, and shall here is a key word that became an instrumental and pivotal word in the Almarez and Guzman proceedings. So this law tells us that we shall incorporate the descriptions and measurements of physical impairments and the corresponding percentages of impairment published in the AMA guides. So one of the key things that happened in the Almarez and Guzman proceedings is that qualified medical evaluators were attempting to go outside of the AMA guides in providing for alternative impairment ratings. And they did this in many different ways. And one of the primary ways that qualified medical evaluators went outside the guides is they went outside the guides by referring to prior permanent disability rating schedules in describing the examinee's impairment and or disability. As I said, Labor Code 4660 became effective 1/1/2005, and so qualified medical evaluators were starting to refer to the permanent disability rating schedule in effect prior to 2005 in describing the examinee's permanent disability. But that was found to go contrary to law, because Labor Code 4660 clearly established that the nature of the physical injury or disfigurement shall incorporate, meaning must incorporate the descriptions found in the AMA guides. And therefore, this is what closed the door on qualified medical evaluators' attempts to describe the examinee's impairment, in this case, by going outside the confines of the AMA guides. And we'll see what the Almarez and Guzman cases had to say about the confines of the AMA guides. So Labor Code 4660C tells us that the schedule, meaning the new permanent disability rating schedule that takes into consideration the nature of the injury and disfigurement, the occupation of the employee at the time of injury, the age of the employee at the time of injury, and the diminished future earning capacity adjustment factor. That's what's known as the schedule, the permanent disability rating schedule, shall be prima facie evidence of the percentage of permanent disability to be attributed to each injury covered by the schedule. So prima facie means based on first impression, or it's the accepted as correct until proven otherwise permanent disability percentage for each injury. So the schedule that we use, in other words, the permanent disability rating that spits out after the application of the schedule, shall be accepted as the correct permanent disability rating until proven otherwise. So in order to prove that the schedule is not the correct permanent disability rating, or that the schedule doesn't provide the correct permanent disability rating, the schedule has to be rebutted, has to be found as the incorrect, an incorrect permanent disability rating. And that's the whole philosophy of alternative impairment ratings under Almarez and Guzman, is to rebut the schedule and show that the scheduled rating is not correct. So in other words, in providing for alternative impairment ratings, the scheduled rating has to be rebutted. And in order to properly rebut the scheduled rating, your argument as the qualified medical evaluator has to be good, and it has to be done properly. And that's the purpose of this program, is to show you how to properly rebut the permanent disability rating that's provided for by the schedule. And then the Almarez and Guzman proceedings kind of put an exclamation point on their requirement that we stay within the four corners of the AMA guides by quoting and reiterating Labor Code Section 4660D, which tells us that the schedule, which relies on the measurements, charts, and tables of the AMA guides, shall promote consistency, shall promote uniformity, and shall promote objectivity. And what the Almarez and Guzman proceedings exposed was that qualified medical evaluators' attempts to describe the permanent disability rating by going outside the four corners of the AMA guides was compromising consistency, was compromising uniformity, was introducing inconsistency, and was introducing non-uniformity in the permanent disability ratings. So the law is clear that through use of the AMA guides and through use of the schedule in providing for permanent disability ratings shall promote consistency and uniformity across all evaluators, across all examinees, and across all specialties throughout the entire state of California.
Okay, so let's read from the Almarez and Guzman decision. They tell us that in this decision, and these are the conclusions of the case, we hold that, number one, the language of Labor Code Section 4660C, which provides that, quote, the schedule shall be prima facie evidence of the percentage of permanent disability to be attributed to each injury covered by the schedule, unambiguously means that a permanent disability rating established by the schedule is rebuttable. And that's based upon the plain language of the law, which describes prima facie evidence. And as we saw, prima facie simply means that the evidence is presumed to be correct unless that evidence can be rebutted and be proven to be incorrect. So the plain language of the law is unambiguous, and it tells us that the schedule is rebuttable. Okay, so this opens the way to alternative impairment ratings in those cases where the strict impairment rating provided by the strict application of the AMA guides is considered to be not accurate. However, the burden of rebutting a scheduled permanent disability rating rests with the party disputing that rating. So generally this involves the applicant arguing that the scheduled permanent disability rating under the AMA guides is too low and that the employee or examinee actually qualifies for a higher permanent disability rating than that which is provided for under the schedule, under the scheduled permanent disability rating. Now, one method of rebutting a scheduled permanent disability rating is to successfully challenge one of the component elements of that rating, such as the injured employee's whole person impairment under the AMA guides. And when determining an injured employee's whole person impairment, it is not permissible. This is new. It is not permissible. This is the new en banc decision. It is not permissible to go outside the four corners of the AMA guides. However, in order to promote consistency, uniformity, and objectivity, a physician may use any chapter, table, or method within the AMA guides that most accurately reflects the injured employee's impairment. And it's staying within the four corners of the AMA guides that promotes consistency, that promotes uniformity, and that promotes objectivity, whereas going outside the AMA guides would introduce subjectivity, non-uniformity, and inconsistency, and permanent disability ratings that are all over the place. And by keeping within the four corners of the AMA guides, at least the permanent impairment ratings are contained within the consistency and the objectivity found within the AMA guides. But then, of course, they give us some caveats. After opening up the four corners of the AMA guides and allowing us to use any chart, table, or method described in the AMA guides, they give us a couple of constraints. And they tell us that we emphasize that our decision does not permit a physician to utilize any chapter, table, or method in the AMA guides simply to achieve a desired result. Now, what would be some desired results that would cause a physician to depart from the chapter, to depart from the table, or to depart from the method traditionally described in the AMA guides in describing the examinee's permanent impairment? What would be a desired result? Well, typically, alternative impairment ratings under Almarez and Guzman have the effect of increasing the permanent impairment rating compared to the strict application of the AMA guides, similar to providing permanent disability ratings based directly or indirectly on any schedule in effect prior to 2005, such as the 1997 permanent disability rating schedule. So they tell us that our opinion regarding an injured employee's whole person impairment under the guides must constitute substantial evidence. Therefore, the opinion must set forth the facts and reasonings which justify it, and moreover, a physician's whole person impairment that is not based on the AMA guides does not constitute substantial evidence. So this is important, and this is an important principle, and this is something that plays itself out into each and every one of the opinions that we offer regarding permanent impairment. If you're going to depart from the strict application of the AMA guides and use a different chapter, a different table, or a different method in the AMA guides, this is going to have the likely impact of increasing the permanent impairment rating. Well, if you're going to increase the permanent impairment rating, your reasoning for doing so must constitute substantial medical evidence, and you must set forth the facts and reasoning which justify a departure from the AMA guides and which justify the utilization of a new alternative impairment rating under a different chapter, under a different table, or under a different method in the AMA guides. And if you're going to do that, it has to be done exactly correctly and I'll share with you the procedure for doing exactly that in just a couple moments. So as long as you can qualify your opinion for an alternative impairment rating as substantial medical evidence, you're basically unshackled and unfettered and can peruse the entirety of the AMA guides in coming up with an alternative impairment rating that, in your opinion, is a more accurate description of the examinee's true permanent impairment. And here's the phraseology from the Almarez and Guzman cases that unshackles us as qualified medical evaluators. They tell us that, nevertheless, although the whole person impairment component of a scheduled rating must be founded on the AMA guides, a physician is not inescapably locked into any specific paradigm for evaluating whole person impairment under the guides. 4660B1 provides that the whole person impairment component of a scheduled rating is to be rooted in, quote, the descriptions and measurements of physical impairments and the corresponding percentages of impairments published in the AMA guides, unquote. Okay, so there's step one. Our whole person impairment must somehow, somewhere be rooted in the text within the body of the AMA guides, but section 4660B1 does not mandate that the impairment for any particular condition must be assessed in any particular way under the guides. And this is what unshackles and unfetters us as qualified medical evaluators and basically allows us to use our imagination in utilizing the four corners of the AMA guides. They tell us that while the AMA guides often sets forth an analytic framework and methods, some framework and methods for a physician in assessing whole person impairment, the guides does not relegate a physician to the role of simply taking a few objective measurements and then mechanically and uncritically assigning a whole person impairment that is based on a rigid and standardized protocol and that is devoid of any clinical judgment. And here is where the applicant attorney that contended that the AMA guides deferred to the evaluating physician's clinical judgment was proven correct. And they conclude by telling us the AMA guides expressly contemplates that a physician will use his or her judgment, his or her experience, his or her training, and skill in assessing whole person impairment. Okay? So let's take a look at the key conclusions then, the operative conclusions of this important decision.
So let's summarize some of the key conclusions that came out of the en banc decisions of the Almarez and Guzman cases. And I've provided this entire document for you in your reading materials as part of this program. And the main conclusion from the Almarez and Guzman decisions is that a permanent disability rating which is established by use of the schedule is rebuttable. It can be found to be an inaccurate or an incorrect rating. Well, the burden of rebutting a scheduled permanent disability rating rests with the party who's disputing the rating. Remember, Labor Code 4660 tells us that the permanent disability rating that's established by the schedule is prima facie evidence of the correctness of the schedule. So the scheduled rating is presumed to be correct unless proven otherwise, and the party that attempts to prove otherwise has the burden of proving it. So in some cases, the applicant will rebut a overly low permanent disability rating and attempt to prove that a higher disability rating is more accurate. And in other cases, the defense attorney will attempt to prove that an alternative impairment rating is too high and that the scheduled rating is the more accurate rating. So the burden of rebutting a scheduled rating rests with the party who's disputing it, who's disputing the rating. So one method of rebutting a scheduled permanent disability rating is to successfully challenge one of the component elements of that rating. And remember, there were 4 component elements of the rating, one of which is the whole person impairment rating under the AMA guides. So this seems to provide the greatest source of opportunity for rebutting the rating established by the schedule, is to successfully challenge the whole person impairment under the AMA guides by showing that the whole person impairment rating under the AMA guides is incorrect or is not the most accurate description of the examinee's permanent impairment. And the Almarez and Guzman conclusions were that physicians can successfully challenge the standard ratings provided by the charts, tables, and chapters in the AMA guides by allowing the qualified medical evaluator to utilize any chapter, any table, or any method in the AMA guides that most accurately reflects the injured employee's impairment. So now we're not pigeonholed, we're not limited, we're not constrained to any particular table in the AMA guides. We're not constrained to any particular chapter, but we have the freedom to utilize the entirety of the AMA guides, the four corners of the AMA guides, to come up with permanent impairment ratings that are the most accurate description of the injured employee's impairment. And we're going to talk about how to most accurately describe the impairment by talking about several steps and procedures that your alternative opinion on the permanent impairment rating has to pass through in order to pop out the bottom of the truth filters and be an accurate description of the injured employee's impairment. You can't simply go on a fishing expedition throughout the AMA guides to come up with permanent impairment ratings that achieve a better or higher permanent impairment rating, but rather the alternative impairment rating using a different chapter, a different table, or a different method has to successfully qualify as substantial medical evidence to be considered to be the most accurate description of the injured employee's impairment. And we'll talk about that as we progress through today's discussion. Now, in the beginning, when Almarez and Guzman was first adopted in 2009, it seemed that providing for alternative impairment ratings was optional, that it was not a requirement. But in time since 2009, a consideration of alternative impairment ratings under Almarez and Guzman is now required in every single case. So even if you do not use an alternative impairment rating to describe the examinee's impairment, you still need to show the parties that you considered the range of impairments that could be applicable to the examinee. And here's how you can do that in your report. You create a section in your report with this heading, Alternative Impairment Rating under Almarez and Guzman. And this would go directly underneath the permanent impairment heading in your report. So let me rephrase that. In your report, you have a topic heading entitled Permanent Impairment, under which you would elaborate on all the permanent impairments that relate to your examinee under the strict application of the AMA guides. And you would do a fabulous job in that section of your report. You would sum it up, total it up, and provide the parties with a final permanent impairment rating under the strict application of the AMA guides. Well, then under that section, also under the permanent impairment section of the report, this is a subheading under the permanent impairment major heading in your report, you provide this topic heading, Alternative Impairment Rating under Almarez and Guzman. You would simply say something similar to the following. In my opinion, and within reasonable medical probability, the above permanent impairment rating under the strict application of the AMA guides is the most accurate description of Mrs. Smith's impairment. I do not find a need to consult with other charts, tables, or chapters within the AMA guides to more accurately describe the impairment. And this statement is satisfactory to demonstrate to the parties that you indeed considered other charts, other tables, other chapters, other methods within the AMA guides, and even though you did so, you believe that the permanent impairment rating provided for by the schedule under the strict application of the guides is the most accurate description of the impairment. Now, in the contrary, if you believe an alternative impairment rating applies to the examinee and you decide to provide for an alternative impairment rating under Almarez and Guzman, that opinion would also go under this same topic heading, alternative impairment rating under Almarez and Guzman, but your description of it would be greatly, greatly different, of course. And your description of the alternative impairment rating has to satisfy several important criteria in order for that alternative impairment rating to qualify as substantial medical evidence and in order for it to be upheld by the parties. So let's go into that discussion now as to how to provide for alternative impairment ratings that will be upheld by the parties and that do qualify as substantial medical evidence. So let's talk about substantial medical evidence. Now, every time you offer an opinion and conclusion within the body of your report, you need to make sure that every single one of those opinions and every single one of those conclusions qualify as substantial medical evidence. Now, all of us are familiar with opinions and all of us are familiar with conclusions, and we all provide both of these in our conversations and in our QME reports. And substantial medical opinions are to be differentiated from conclusory opinions in this context. Now, conclusory opinions, unlike substantial opinions, do not provide a reasoning or a basis for the opinion. So let me give you an example of a conclusory opinion that you will see in qualified medical evaluators' reports. A conclusory opinion on permanent impairment would be something similar to the following. In my opinion, the DRE method is the more accurate description of Mrs. Smith's impairment versus the range of motion method, period. That's a conclusory opinion. Let me give you an example of another conclusory opinion regarding apportionment. In my opinion, 60% of the permanent impairment is due to the industrial injury, and 40% of the permanent impairment is due to other factors. Conclusory opinions provide only the conclusion. A conclusory opinion that does not explain or provide the reasons why or the reasons behind the opinion are not substantial opinions. So substantial opinions take the conclusory opinion and explain them and support them and provide the how and why reasoning and gives point after point after point after point in support of the conclusory opinion. So substantial medical evidence as far as qualified medical evaluation reports was strongly substantiated with the Escobedo case, which told us in its major conclusion of the Escobedo case, told us that in order to constitute substantial medical evidence, a medical opinion must be, first of all, predicated on reasonable medical probability. So every time you offer an opinion or conclusion in your report, predicate it on reasonable medical probability. And you do that by using a phrase similar to the following. In my opinion, comma, within reasonable medical probability, comma, such and such and such and such and such and such, and provide the opinion. So you predicate it in advance on reasonable medical probability. And all you have to do is use that simple phrase. In my opinion, comma, within reasonable medical probability, comma, and then you provide the opinion or conclusion. Escobedo told us that a medical opinion is not substantial medical evidence if it's based on facts no longer germane, if it's based on inadequate medical history or examinations, if it's based on incorrect legal theories, or if it's based on surmise, speculation, conjecture, or guess. Further, a medical report is not substantial evidence unless it sets forth the reasoning behind the physician's opinion, not merely his or her conclusions. Simply providing your conclusions is a conclusory opinion. A substantial opinion must set forth the reasoning behind your opinions, and the more reasons you have in support of your opinions, the more substantial your opinion will be. So every time you provide an opinion or conclusion in your report, you must support it with bullet point after bullet point after bullet point of reasons which support that opinion or conclusion. An opinion or conclusion that cannot be supported with multiple, voluminous, and compelling bullet-pointed reasons is probably not an opinion that's true. It's probably not an opinion that's accurate. It's probably not an opinion that applies. Why doesn't it apply? Why isn't it accurate? Why isn't it truthful? Because it has no support. It's not an opinion that can be strongly supported with multiple and compelling reasons. Further, one of the best ways that the parties can attack your opinions as not being substantial opinions is to show that your opinion is based on an inadequate examination. And I see qualified medical evaluators' reports all the time that contain inadequate examinations that do not use range of motion procedures described in the AMA guides, that do not use range of motion normal findings described in the AMA guides. And there's 100 different examples of inadequate examinations. I was reviewing a qualified medical evaluator's report the other day, and his neurologic examination for a spine injury included only reflex testing, did not include sensory testing, did not include motor testing, did not include nerve tension sign testing. And so it was certainly an inadequate examination. So in order for your opinions and conclusions to be substantial opinions and conclusions, they must be based on a fabulous examination, because only a fabulous examination produces true and correct physical exam findings. Okay, another way to attack your opinion or conclusion as not a substantial opinion or conclusion is to show that you're guessing, that you're simply making stuff up, you're just speculating, you're just conjecturing, you're just surmising and basing your opinion on stuff that has no basis, it has no reasons, and it has no support. So substantial medical opinions are much different from conclusory opinions. And I want you to go through your reports and identify those opinions that you're offering that attempt to be simply conclusory. See, gone are the days where doctors can simply pound their fist on the desk as if God has spoken and provide conclusory opinions without support. Those days are gone. Now, our opinions and conclusions need to be supported. They need to be based on voluminous and compelling reasons in order to qualify as substantial opinions, and your permanent impairment ratings, your opinion on permanent impairment ratings, certainly have to be substantial in order to be upheld by the parties. So that's the first step in providing alternative impairment ratings under Almarez and Guzman that will be upheld by the parties, is that the permanent impairment rating first has to be a substantial opinion. Okay, now providing for alternative impairment ratings has some additional requirements as well, which we'll go into in just a couple minutes. But let's find out a little bit more what case law has to tell us about substantial medical evidence. Okay, so a couple of important cases that describe conclusions relating to substantial medical evidence. The Granado case concluded that a mere legal conclusion, in other words, a conclusory opinion, does not form a basis for a finding. In other words, a mere legal conclusion has no value, has no utility in being able to resolve issues within the workers' compensation system. It does not even form the basis for a finding. Zemke tells us that an opinion that does not disclose its underlying basis and gives a bare legal conclusion does not constitute substantial medical evidence. Let me give you an example. Imagine at your home, you had a roof inspector come out to inspect your roof. And for whatever reason, you called a roofing expert out to your roof to check out your roof. Well, after just a very few minutes, the roofing inspector comes to you and he tells you you need a new roof. It's going to be $20,000. In other words, he provides for you a conclusory opinion that you need a new roof. The bottom line, the conclusion is you need a new roof. A mere roofing inspection conclusion. You need a new roof. What is your natural reaction going to be, and what is your next question going to be? Your next question is going to be, well, what do you mean I need a new roof? What in the world? What are you talking about? What do you base that on? What were your findings? What are you telling me? What's up there? What's going on? And you're going to want to know reasons, and you're going to want to know the underlying basis underneath his conclusion that you need a new roof. Now imagine that the roofing inspector begins to give you reasons as to why you need a new roof. And he gives you a reason such as you have a dent in your gutter. Now, are you going to be convinced that because you have a dent in your gutter, you need a new $20,000 roof? No, you're not. But if the roofing inspector gives you multiple bullet points of reasonings that are based on an adequate examination of the roof and are based on significant facts regarding your roof, then you're going to be more compelled to believe the conclusion of the roofing inspector. So he comes to you and he says, well, you're missing shingles on the back right quadrant. In the front, there is tears in the undersurface papering. Across the top, across the eaves, you have X finding, and across the back you have Z finding, and A, B, C, D, and he elaborates a list of findings that shows you and clearly convinces you, and he brings you pictures of what he found, and he substantiates his conclusion through multiple facts, multiple reasons, and a full examination of your roof. Only then are you going to be compelled to accept the conclusion as an accurate conclusion that in fact you do need a new roof and it's going to cost you $20,000 to replace this roof. So in your personal life, you require that opinions and conclusions have some basis, have some reasoning, that they be substantial opinions. And in the work that we do, which is so important, it's the same. Now, the Bassett case told us that the chief value of an expert's testimony rests upon the material from which his or her opinion is fashioned. The material, the reasons, the references, the citations, the facts, the findings, the X-ray evidence, the physical exam findings, the historic facts, the material from which his or her opinion is fashioned, and the reasoning by which he progresses from the material to the conclusion. And it does not lie in the mere expression of the conclusion. You need a new roof. Thus, the opinion of the expert is no better than the reasons upon which it is based. And you're familiar with this concept in your personal life, and it's now being applied to our medical legal evaluations, in that each opinion and conclusion that you offer within the body of your report has to be supported by voluminous and compelling reasons. The more voluminous and the more compelling are the reasons, the more substantial is the opinion. So let's talk about how to apply substantial medical evidence to your alternative impairment ratings under Almarez and Guzman. So in order to do that, a little bit of supporting philosophy came out of the Guzman 3 decision, which told us that the decision does not allow a physician to conduct a fishing expedition through the guides simply to achieve a desired result. The physician's opinion must constitute substantial evidence of whole person impairment, and therefore it must set forth the facts and the reasoning that justify it. Now, you have to realize that providing for alternative impairment ratings many times has the effect of doubling, tripling, quadrupling, heptupling, non-tupling, in other words, 9 times, 10 times the permanent impairment rating. And so we're not allowed to use alternative impairment ratings simply to achieve a higher permanent impairment rating for the examinee. Alternatively, the opinion must set forth the facts and the reasoning that justify it. And if you're going to double or triple an examinee's permanent impairment rating, in order for the parties to accept that rating and compensate the examinee in accordance with that rating, it better be supported by facts, and it better be supported by voluminous and compelling reasons. Otherwise, the parties will simply reject it as an opinion that's not substantial. So the Guzman decision goes on and tells us that simply presenting a view contrary to an established rating in the guides would not be sufficient to rebut the Permanent Disability Rating Schedule rating, which, remember, the Permanent Disability Rating Schedule rating is prima facie evidence of the accuracy of the rating. So simply providing a view contrary to the prima facie rating is insufficient. An impairment rating that is inadequately supported by evidence and reasoning, and certainly or unquestionably a rebuttal position arrived at by hunting through the guides for a more favorable or higher rating, will certainly result in an opinion that the workers' compensation judge will necessarily reject as insufficient evidence. Well, in order to constitute substantial medical evidence under Almarez and Guzman, the most important thing is that you be able to explain to the parties why. Number one, the impairment rating under the strict application of the AMA guides is not accurate, and why an alternative impairment rating under Almarez and Guzman is more accurate. So the key question that has to be answered in order for your opinion to qualify as substantial medical evidence is why. And this was established in the Martinez versus the City of Bakersfield case, which concluded that in order to support a case for rebuttal, in other words, in order to rebut the scheduled rating under the AMA guides, the physician must be permitted to explain why a departure from the impairment percentage is necessary and how he or she arrived at a different rating. Without a complete presentation of the supporting evidence on which the physician has based his or her clinical judgment, the trier of fact may not be able to determine whether a party has successfully rebutted the scheduled rating or instead has manipulated the guides to achieve a more favorable impairment assessment. So, as qualified medical evaluators, we need to quicken our thinking into the realm of how and why. How and why. Why we depart from the AMA guides, and why we employ an alternative impairment rating, and how we arrive at the alternative impairment rating. Now, I'm going to give you the exact formula as to how to explain to the parties why you departed from the strict application of the guides and how you arrived at your alternative impairment rating. But before I do that, remember, it's important to remember that under Almarez and Guzman, many times the Almarez Guzman alternative impairment ratings allow for doubling, tripling, quadrupling, etc. the permanent impairment rating that's found under the schedule, under the strict application of the AMA guides. So this is going to catch the party's attention when you attempt to double, triple, and quadruple the costs associated with compensating the examinee in the form of a permanent disability award. So it has to be done just right. It has to provide for an accurate permanent impairment rating of the examinee. Otherwise, it will be promptly rejected by the parties as simply your attempt to manipulate the guides in order to obtain a more favorable result. So therefore, the use of an alternative impairment rating has to follow some exacting rules, which I'm going to give you now. So a consideration of Almarez Guzman alternative impairment ratings is required in every single case that involves permanent impairment, because this consideration of an alternative impairment rating contributes to what's referred to as a complete medical evaluation. So we're now required in every case to go through the AMA guides and to go through our mental Rolodex and think to ourselves, is it possible that there's another chart, another chapter, another table within the AMA guides that could possibly be a more accurate description of the examinee's impairment? Because our job as qualified medical evaluators is to most accurately describe the examinee's permanent impairment rating so that that permanent impairment rating can be plugged in to the schedule down at the disability evaluation unit. An inaccurate permanent impairment rating is going to provide for a permanent disability rating or permanent disability percentage that's inaccurate and does injustice or does not do justice to the injured worker. So in order to do justice and to do the proper thing for the examinee, it's critical that we accurately describe the permanent impairment in every single case. And that involves a consideration of alternative impairment ratings in addition to the impairment ratings that are provided under the strict application of the AMA guides. And this is clearly described in the Guzman decision, which tells us to accommodate those complex or extraordinary cases. And in the Guzman decision, they referred to complex or extraordinary cases as those cases where the permanent impairment rating is either not listed in the AMA guides or is not clearly described in the AMA guides. But this now applies to all cases. The AMA guides calls for the physician's exercise of clinical judgment to evaluate the impairment most accurately. Most accurately. We're required to most accurately describe the impairment, even if that is possible only by resorting to comparable conditions described in other charts, other chapters, and other tables of the AMA guides. So in every single case that involves a permanent impairment rating, you must provide an opinion as to whether a permanent impairment, whether an alternative impairment rating under Almarez and Guzman would be more accurate, or whether an alternative impairment rating under Almarez and Guzman is not more accurate. So we're required to consider the entire range of permanent impairments that may apply to our examinee in every single case that involves permanent impairment. So here's the magic formula. This was described in the Kramer versus County of Sonoma case. In order to properly rate using Almarez and Guzman, the doctor is expected to do some certain things, and I'll explain those to you in just a second. So I want you to imagine your report. In the permanent impairment section of your report, under the heading Permanent Impairment, you're going to go ahead and provide the permanent impairment rating under the strict application of the AMA guides. And you're going to go through your normal methodology as to how the AMA guides would rate a certain condition in the chapter associated with that condition using the charts and tables that describe impairments associated with that condition. So you're going to go through your entire formulation of providing a strict rating per the AMA guides. And that is step number 1. Then underneath that whole discussion, you're going to create a new subheading, and this is under the main topic heading of permanent impairment. So the subheading is alternative impairment rating under Almarez and Guzman. And in this section, this subsection under the permanent impairment section of your report, you're going to, number 1, you're going to reiterate your strict rating that you came up with in the preceding section of your report. So you might simply say something similar to the following. In my opinion, Mrs. Smith's impairment rating under the strict application of the AMA guides is 16% whole person impairment, period. See discussion above. And you refer the reader of your report to the section above wherein you went through the entire formulation as to how you arrive at the permanent impairment rating of 16% whole person. Then in a new paragraph, you're going to go through step number 2 in the procedure to properly rate using Almarez and Guzman. Step number 2 is you're going to explain to the parties why the strict rating does not accurately reflect the applicant's disability. Now, your reasoning why the strict rating is not accurate had better be good. It had better be good. It has to be good. It has to be good reasons. You need to have multiple, voluminous, and compelling reasons as to why the strict rating is not accurate. Now, more important than voluminous reasons are compelling reasons. I suggest that your reasons be voluminous and compelling. Now, this is where the litmus truth test comes into play. This is where your opinion starts passing through those filters that I was talking about earlier in the discussion. If you're not able to come up with voluminous and compelling reasons as to why the strict rating is not accurate, then guess what? The strict rating is accurate. If you don't have reasons as to why it's not accurate, then by default, by prima facie evidence according to the law, then the strict rating is the most accurate. So your reasons here have to be good. Has to be good. You have to be able to convince yourself. When you review this section in your report, you have to be able to convince yourself that the reasons that you provided are good, that they're compelling, that they're convincing. Now, these reasons are not simply restatements of facts. You have to explain why these facts contribute to a rating that's not accurate, and it has to be good. Once you're done with that, then you go through step 3 in the procedure for properly rating under Almarez and Guzman, and that is to now provide the parties with an alternative rating within the 4 corners of the AMA guides. So herein is where you have the opportunity to go ahead and provide the rating that you feel is a more accurate rating, whether that be a rating in a different chapter, whether it be simply a rating within the same chapter but using a different method, whether it be a rating method that applies a set of different rules that are typically associated with a chart or a table in the AMA guides. Whatever your alternative methodology is, this is where you have an opportunity to provide it to the parties. And then finally, in a separate paragraph, so these are all in separate paragraphs, in a final paragraph, you have to explain to the parties why that alternative impairment rating most accurately reflects the applicant's level of disability. Most accurate. In other words, why is it more accurate than the impairment rating that's provided for under the strict application of the AMA guides? And here you must have voluminous and compelling reasons, and they better be good. They better be good. You yourself have to convince yourself that these reasons are good first. If you yourself are unconvinced, guess what the parties will be? Do you think the parties will be convinced that they should adopt your doubling, your tripling, your quadrupling, your more favorable result, your more desirable alternative impairment rating? Do you think the parties are going to accept it and adopt it with its doubling, tripling, and quadrupling of costs if the reasons behind it are not good? They have to be good. You have to be convinced yourself first before you can attempt to convince the parties. Now, if you're not able to provide multiple and compelling reasons as to why the alternative impairment rating is more accurate, then guess what? It's not more accurate. Unless it can be supported by compelling reasons, then the strict application rating by default is the more accurate rating. So don't provide an alternative impairment rating unless you have reasons in support of the rating. An alternative impairment rating without compelling and voluminous reasons is simply a conclusory opinion that does not qualify as a substantial opinion, and it will properly be rejected by the parties. So imagine this. Let's go back to your report now. Let's take a look at your report. In your report, this section would be formatted somewhat as follows. So this is under a separate subheading in your report entitled Alternative Impairment Rating under Almarez and Guzman. Step number 1. In my opinion, the above permanent impairment rating, In my opinion, Mrs. Smith qualifies for 16% whole person impairment rating under the strict application of the AMA guides, period. See discussion above. There's step 1. New paragraph. In my opinion, the above impairment rating of 16% whole person impairment is not the most accurate reflection of Mrs. Smith's true impairment, period. Reasons for this conclusion include : new line, bullet point, reason number 1, and explain the reason why it's not accurate. Reason number 2, explain why it's not accurate. Reason number 3, explain why. And the more reasons and the more compelling are your reasons, the better. Step number 3. In my opinion, Mrs. Smith's impairment rating is most accurately described as such and such, and you go here into the chart, table, or chapter of the AMA guides that more accurately describes the impairment rating and give the final percentage of the rating. Finally, step number 4, in my opinion, the above alternative impairment rating of, let's say, 30% whole person impairment is the most accurate description of Mrs. Smith's impairment, period. Reasons for this conclusion include : new line, reason number 1, and explain why the alternative impairment rating is most accurate. Reason number 2, explain why it's most accurate. Reason number 3, explain why. And the more reasons, the more voluminous reasons, and the more compelling are the reasons, the more accurate and the more truthful and the more appropriate is the alternative impairment rating compared to the strict rating under the scheduled rating of the AMA guides. So doctors, can you see how this 4-step procedure that we use to qualify the opinion as substantial medical evidence, can you see how this serves as a series of truth filters? If your opinion as to why the strict rating is not accurate. If your opinion is not true, it'll get clogged right here because it's not supported by reasons. If you are able to support the opinion with reasons, then the opinion passes through the filter. Then, if you're not able to provide an alternative impairment rating that's supported by multiple and voluminous reasons, the opinion gets stuck right here. It doesn't pass through the filter as to why, the why filter. It gets stuck in the why that alternative rating most accurately reflects applicant's level of disability filter. Only an opinion that's supported by multiple, voluminous, and compelling reasons can pass through the filter to drop out the bottom as an opinion that qualifies as a substantial opinion, which is an opinion that can be used by the parties. So you need to go through this procedure with every single case and decide for yourself if you're going to provide an alternative impairment rating based upon whether or not the opinion successfully passes through the truth filters. And the litmus test as to the substantiability of the opinion is the voluminous and compelling reasons. They have to be compelling reasons.
So doctors, isn't that a fascinating sequence of events? First we had the passage of Senate Bill 899, which had as its express legislative intent to address skyrocketing costs in workers' compensation. And the purpose of Senate Bill 899 was to reduce those skyrocketing costs. In one way that Senate Bill 899 targeted skyrocketing costs was to reduce permanent disability ratings by changing the permanent disability rating schedule to a more conservative schedule that involved the use of the AMA guides. So we saw that with both Almarez and Guzman, the scheduled impairment rating under the AMA guides was significantly lower than the prior scheduled rating under the 1997 permanent disability rating schedule. So Senate Bill 899 had some initial success in reducing permanent disability ratings and addressing skyrocketing costs, but then along came the Almarez and Guzman's decisions, which effectively allowed qualified medical evaluators to provide for doubling and tripling and quadrupling and even hectupling permanent disability ratings, thereby negating the initial intent of Senate Bill 899. So a couple things to remember as we conclude our program today. Number one, is Almarez and Guzman operative in every single case that crosses your desk? Do you need to consider Almarez and Guzman alternative impairment ratings in every single case? Well, no. The answer is no to that, because alternative impairment ratings are only applicable in those cases wherein you determine that the examinee is permanent and stationary, and you determine that the examinee qualifies for a permanent impairment rating. It's not applicable in those cases that are ordered under Labor Code 4060 for a compensability exam. In those cases, the disputed issue is under AOE-COE and is not related to permanent impairment. It's only those cases where the examinee is permanent and stationary, is at maximum medical improvement, and for which you provide a permanent impairment rating. Now, in every single one of those cases that involves a permanent impairment rating, you're required to address whether or not an alternative impairment rating is the most accurate description of the examinee's condition. So in every single case that involves a permanent impairment rating, you must address then Almarez and Guzman and either provide for a no opinion that an alternative impairment rating is not more accurate in this case, or a yes opinion in that an alternative impairment rating is the most accurate description of Mrs. Jones' impairment. And if you opine yes that an alternative impairment rating is the most accurate description of Mrs. Jones' impairment, you then must follow the four-step formula to qualify your opinion as substantial medical evidence. And let me tell you this, if you cannot go through the four-step procedure to qualify your opinion for a higher double, triple, quadruple impairment rating, to qualify it as substantial medical evidence, don't send it out. Don't send it out, because it'll become clear to the parties that you're simply trying to achieve a better result. Now, if an alternative impairment rating truly is the most accurate description of the examinee's permanent impairment, then the reasons in support of that higher double, triple, quadruple permanent impairment rating will successfully pass through the truth filters and will land on the page of your report as a substantial opinion for a higher permanent impairment rating. So make sure to follow the 4-step formula in every single case and put some time and effort into reviewing your opinion through the 4-step procedure, the 4-step truth filter procedure, to truly determine that the alternative impairment rating is the most accurate description of the examinee's impairment. That's all we're after. That's all any of the parties want, is the true, most accurate description of the examinee's impairment. And if you can qualify your opinion as substantial medical evidence, that will be the impairment rating that the judge provides for the examinee. Okay, so doctors, I hope this helps you. It's a fascinating discussion on Almarez and Guzman, which is operative in just about every single case that crosses our desk, at least in those cases where the examinee is permanent and stationary. So I want to thank you for taking the time to join me on today's discussion. Look forward to being with you on future discussions as well. And for now, this is Dr. Perry Carpenter. I'm wishing you the best of success in your career as a qualified medical evaluator.